A deposition in a personal injury case provides the defendant's attorney an opportunity to question the plaintiff on all aspects of the case, including pedigree information, extensive detailed questioning regarding the accident itself, follow-up medical treatment, and current limitations. Your attorney will be present to make any necessary objections, most of which you will be permitted to provide an answer over the objection. Do not think of the deposition as an opportunity to present your case, but rather a requirement to answer those questions that are asked. In other words, only answer the questions asked. However, please understand that your testimony is most of the evidence in a civil personal injury action, and therefore, it's important not to be so defensive that your answer prevents you from explaining further in later court testimony or affidavit if required. In other words, keep your answers within the scope of the question. If the attorney fails to cover all relevant subject matters of the case, then it will be to the defendant's detriment, not yours. Also, understand that the defense attorney's objective is not to trick or cross-examine, but rather cover all relevant areas of the case, so that you as a plaintiff are locked into a position, whatever that position may be. Many depositions can run several hours of questions. Patience is critical. Oftentimes, a deposition can be 100 or more pages of testimony and only 2 or 3 questions are offered in cross-examination at the time of trial. It is therefore important to remain patient throughout the questioning process, as you will not know until the end what questions or answers will be used against you in your case. Be prepared to provide resident information for the past 10 years, work history, educational background, and the happening of the accident in significant detail. In terms of medical treatment, the doctor's names, addresses, and how you came to see the particular provider, what was done by way of medical treatment, and diagnosis information provided to you. Also, be prepared to discuss current limitations. There are generally 2 questions, the first of which are things that you cannot do at all that you could before, and the second are things that you can do, but are limited in nature. Think of all daily examples of such limitations, and be prepared to answer these questions fully. They are important to your case. As to the mechanics of the accident, there is no substitute for a one-on-one preparation with your attorney. One common mistake many plaintiff witnesses make is their failure to recall any observations of conditions or causes of the accident observed immediately after the occurrence. Understandably, a person who sustains serious injury would like to forget everything that is observed after an accident due to pain or just the desire to not have to relive the occurrence. However, depending upon the type of accident, observations of conditions immediately after an accident can make the difference between winning and losing a case. If you require an interpreter, please allow the full interpretation to be made even if you understand the question, and then only answer back in the language provided. For all witnesses, take your time in formulating your answers. It is, in fact, a good idea to take a breath after hearing the question and then express your answer. Do not think out loud. Every word spoken is recorded by the court reporter. The deposition is nothing to fear. A good measure of preparation and patience will go a long way in providing for a good outcome.